discussions over the past couple of years. I think, although guys doing different kind of work, it's a different way of looking at litigation that in discussing this with Guy, I found to be very interesting, and I'm looking forward to the presentation.
Thank you. Hi, thanks for coming. And given that we're running a little late, I start immediately. So I want to give you a broad description of my thesis and my project. And basically my objective is to engage in normative analysis of the design of multi-party collectivized law enforcement devices. And when I talk about this title, about collectivized law enforcement devices on behalf of multi-parties, I'm talking in particular about class action litigation, although in the landscape of American litigation there are additional devices which are not presently included in my project. In order to engage in this, to attain this objective, it is necessary to develop a comprehensive analytical framework in order to examine the present situation and to prescribe legal rules that would lead us to attain the optimal design of the law enforcement system. The normative criteria, which I generally subscribe to, are those that relevant to optimally attaining the social welfare objectives of law enforcement. In some context of law enforcement, say in the securities area, it could be deterrence of securities violation and maintaining the integrity or the ability to rely on financial markets. In other areas of litigation, it could be that the social objective underlying the litigation and the imposition of civil liability could be different. But basically, whatever the substance of the social welfare objective, my purpose is to arrive at an optimal design of the litigation devices in every particular area. The methodology which I'm using is, in particular, economic analysis, and as you will see later today, it is also using empirical methods. Overview of my thesis, just a general overview. The first chapter of the thesis, which I will discuss today, is developing a market for securities class action. And when I mean a market model for securities litigation, it means that we have to view the securities law enforcement or securities litigation within a market model. And when I say that, it may strike some of you as an absurd or as peculiar method or approach to think about or analyze litigation and law enforcement. And I will later get into those issues, but in the meantime, you can think to yourself, how would you usually think about litigation, or alternatively, how would you perceive law enforcement? What type of words would come up when you think about litigation and law enforcement? And ask yourself whether a market model is one which comes first in your mind. The second chapter is the one of empirical study of a market structure. Having laid down a market model for securities litigation, I then analyze in particular the market structure of a securities litigation, and I identify and examine the effects of legal regulation on the market structure. And when I mean identify and examine those effects of legal regulation, the legal regulation which I discuss is not regulation of the market, because current rules do not regulate the market in any conscious sense, but rather the legal regime regulates concrete and discrete components of class action litigation, and as I will argue, those regulations have indirect effects on the market generally and on the structure of the market for securities class action litigation in particular. The third chapter, and the final one, is that of normative analysis of the optimal design of the market for securities law enforcement, and this necessitates evaluation of the effects of market structure on the determinants of law enforcement. Or to put it differently, it means generally that I would have to examine how different market structures say, a competitive market structure as opposed to a highly concentrated market structure would affect the attainment of the social objectives underlying civil litigation through class actions. If there are no questions, clarifying questions at that point, I will move forward, but okay.
There's a question.
Okay.
Just to be clear, and are you willing to specify the social objectives, or is that the black box?
That's a black box which I don't
Whatever
really.
social objectives we want to put into that.
I will specify it. I will obviously make it explicit in the chapters, but for the purpose of the presentation today, we can just refer to that as a black box, and whatever substance is put into this black box, then it will shed some light on how those objectives should be pursued and attained in different circumstances and contexts. Ishai.
A short clarifying. When you say that there's a market, there should be a commodity. So what is the commodity?
I'm still going to get into it. That's exactly one of the questions I'm going to get into. To give you a brief outlook on how does securities class action litigation look like, I have a schematic presentation here. And first, we should find a stock price drop. So basically, law firms watch the market, and when they identify or realize that the market price of a stock has dropped, they would try to contemplate legal action. In order to contemplate legal action, they would solicit an investor who would become a plaintiff. And I'm sorry for that. And on behalf of this plaintiff, this investor, they would file a complaint. A complaint which is an individual action, but they would request the court later on to grant it the status of a class action. Later on, what happens is that multiple lawsuits are being filed on behalf of multiple investors by multiple law firms. So we have simultaneously similar lawsuits filed usually in different courts or sometimes even in the same court. What happens then is the phase of consolidation of all similar complaints to economize on judicial resources, and then there is an appointment of a class counsel, which basically means out of all the law firms that filed those complaints, there is one law firm or maybe a team of law firms and the counsel that would be appointed to represent the consolidated legal proceeding. And still, it is not a class action at that phase. What happens next is that the defendant can file a motion to dismiss, basically to get rid of a case. And if the motion is denied, then there is the discovery campaign, which is usually a very costly process for both parties. At the end of the discovery campaign, what we would usually see is a request, a motion for class certification. The plaintiff attorneys would file this motion to get the status of a class action as opposed to individual suit filed on behalf of the individual investors. And if the court grants the status of a class action, then a notice would be published and sent by different means to the class members, potential class members. And this sometimes can run to very high numbers. After this is done, what we would usually see is that the parties, the defendant, the company sued, and the plaintiffs would enter into settlement negotiations, which would end in a proposed settlement. And I'm saying proposed because every settlement in the context of class action litigation is subject to the approval of a court. Without approval, judicial approval of the settlement would have binding effect only on the parties which are represented by the attorneys, but would not have any binding effect on the entire class. And alternatively, we would also observe in some cases, but in a very rare minority, a class trial which would lead to a class judgment. But as I said, most of the cases, about 90% of them, are settled and do not reach the class trial. By the end of all this process, what would happen is that there would be distribution of compensation to the shareholders, to the plaintiffs, according to their share of holding in the stock, and there would be award of attorney fees. Attorney fees are computed by different mechanisms, which I'm not going to go into at that point. first part of my presentation, after this basic introduction, is laying down the model for the market for securities class action. So in advancing the market model, let me go back to the question that I posed earlier. How would we usually think about litigation? How would you usually think about law enforcement? Are we perceiving that as something which is subject to market forces, or usually would look at it and analyze it as something more individualistic, in the sense that it perhaps includes notions of autonomy and day in court for the individual plaintiffs that would like to vindicate their grief or whatever harm they have suffered as a result of the violation that they allege in the lawsuit. What I'm arguing here is that the premise to analyzing class action litigation and law enforcement through class actions is that we should perceive law enforcement as a public good. And this is not my own premise. This is something that is compatible with economic theory of deterrence. We should view the outcome of law enforcement and civil litigation as something which carries benefits to society at large and to the public generally, beyond the parties that are litigating the case itself. Based on this premise, the question is, what determines the volume, the quality, and the outcome of the production of law enforcement? In other words, if we take a look at law enforcement as a good, as a commodity, what forces would determine in the volume of this production, the quality of the goods which are produced by different producers or different manufacturers, and what would be the outcome of this production process?
Let me just ask a clarifying question. Are you saying that law enforcement is always a good? In other words, more enforcement is automatically better?
No, I'm not saying. No, this does not carry the normative implication that more enforcement is always better.
Okay.
Okay, maybe it's not a...
So more of a public good is not necessarily better?
Positive externalities.
There is a positive externality in the sense that it confers benefit upon society. Say deterrence. If the outcome of law enforcement is deterrence,
Right.
so the entire society would benefit from the deterrent effect of litigation,
Yeah.
any litigation.
Right.
But it does not mean that we would want litigation, infinite litigation, to achieve infinite law enforcement and infinite deterrence.
So there's
Obviously,
an optimal
there is
level.
optimal level, right? Because we could, under some circumstances, we would face over deterrence, and in some cases, we would face under deterrence. And there is a social cost calculus which is entered into this analysis. So we would basically,
And your argument is that the market model achieved this optimal.
I'm not necessarily saying that.
You're not- but-
I'm saying that in order to analyze how we could achieve the optimal level of law enforcement, the optimal quantity of those goods, we should look at litigation and law enforcement through class action litigation, in particular, within a market model.
But am I right in just saying that between premise and question, you could have second premise, there is an optimal level
Right.
of law enforcement? 'Cause
Right.
that doesn't necessarily seem to me to
Right.
follow automatically from
Okay.
the claim that it's a public good.
Right.
Is it true for every public good? I mean, every public good has an optimal level.
Yeah.
Also, let's say clean air or something like that.
Well,
Absolutely. I mean,
not
once you-
tomorrow, yeah.
Once you think about the cost component of producing this public good and the other sorts of costs which would, beyond the production of this public good, you would get into the conclusion that there is an optimal level
So the
beyond,
word
of,
good,
beyond which it won't be socially desirable to keep producing this public good.
so the word good is actually a problem because what the word maybe public commodity would be better because otherwise we won't
Yeah,
have
that's
this
why I-
whole thing.
Goods in
The
the-
more good, the better.
It's in
Well,
the
that's-
sense of commodity.
Right. No,
Commodity in the
clearly
sense
it's
of good.
sense of commodity and not in the sense of good as
That's public good.
morally good or something like that.
But that's the difference.
That's-
You know,
No, no,
until
no,
this
I'm saying-
moment, I don't think I've ever fully, I mean, I knew that, but it's true, that public good, I've always thought was a good public good.
Oh.
But there's a
I
general.
mean, goods, obviously goods and services, I've just never thought of it as, okay.
But, well,
My God, 3 or 4 years of listening to law and economics presentations and you.
well, if you go out from my presentation, at least with that.
Yeah, absolutely. No, I knew there was an optimal level, that's why I was trying to get you to flesh it out.
Yeah,
The last one.
sorry, Michal.
It's just a follow-up. I think maybe the word The main problem with public goods is that it's undersupplied. I mean, it's true that it can be
That's right.
oversupplied over there, but the main problem with public goods is because of what Guy described, that actually can cause externalities.
So it
Right.
is often a good public good.
Exactly.
Right. Right, and that's what makes it more correct to use this term as opposed to commodity in the context of litigation and when you speak about
It's
the
just
terms.
easier to see in the context of clean air than securities fraud.
Absolutely. No doubt about that. The first claim I'm presenting is that private, as I said a few times up until now, is that private law enforcement through class action litigation is ought to be viewed and analyzed within a market model. And the market model should include identifying what is the product which we just discussed and which are the supply and demand sides, where law firms and courts and plaintiffs are all intertwined into this analysis. What are the pricing mechanisms which are used in this market to price the commodities produced? And what is the legal regulation or legal intervention within the functioning of this market? And once again, I want to stress this last point. The legal regulation which I'm talking about is not consciously a regulation of a market. The law, through, for example, Rule 23 of the Federal Rules of Civil Procedures or other acts which pertain more specifically to securities litigation, they regulate specific components of securities litigation and class action more generally. They are not perceived by most people, and they consciously are not intended to regulate any market. But once we introduce a market model, then we will be able to see what are the effects, the indirect effects, however, of this regulation.
Guys,
Yeah.
just to summarize the discussion we had. So the product is the number of class action filed per year, or
The product is, it is more intricate to define the product. The product is not only the number of cases or complaints filed, but rather the deterrence effects of those. It is both a function of the number of cases filed and the outcomes, the quality and outcomes of those cases, because you could have very few cases filed but prosecuted meritoriously and with high investment, so you would end up with good outcomes, socially speaking. But you could get also a high level of production of law enforcement, but still the investment of the quality of the prosecution, of the quality of the goods produced would be relatively low, so in the end of the day, it would not be that socially desirable. So it's a complex function of both quality, number, and the outcomes.
Isn't it also true?
Can I, you've now got 5 more minutes. On
That's
your
all I have.
25 Right, but you've been interrupted a bunch of times, so you get 10 minutes, but I think we should maybe let you finish
Right.
and then talk.
I certainly defer to this suggestion. Okay. The benefits of a market model, very briefly. First, it provides a comprehensive analytic framework which is currently non-existent in the present literature, and it provides a new approach to thinking and analyzing class action litigation. Moreover, it delineates what are the determinants that would affect the optimal level of law enforcement. So, for example, issues as asymmetric information in the market or the market structure, market power, and level of competition within this market would all become relevant to determine how should this market be designed in order to achieve, once again, the optimal level of enforcement. And I will skip the rest. Market structure, what are the determinants or what are the features of market structure I'm going to talk about? So first, it's the market shares of market producers. So say, for example, there are plaintiff law firms. The question is, what are the market shares that they each possess? What are the levels of concentration and competition? For example, how many competing firms are there? Are there ad hoc alliances that would reduce competition in the market? Is there any merger and acquisition activity in this market? And as we see, the evidence shows that there is an intense M&A activity. Are there any barriers to entry that would prohibit new entrants, new law firms, less experienced or less capable to enter this market and compete? And what is the market power and market dominance features of different law firms in this market? The next claim is more specifically about the market structure. As I said earlier, the market structure is a determinant, and as I argue, a decisive one, which affect the social outcomes of law enforcement. Or to put this argument somewhat differently, I'm arguing that within the market model, focusing on the market structure, all those determinants that I just mentioned, market power, etc., the way the market is structured is a decisive determinant which would affect the optimal, socially optimal level of law enforcement, of a socially optimal level of producing law enforcement through class action. And there are many different reasons why a market structure, say a competitive one, as opposed to a concentrated one, would affect the optimal level in different ways. And the second claim is that legal regulation, whether it is legislative or judicial, of class action litigation, has indirect effects on the market structure, and the regulation imposes costs and uncertainty, and it sometimes introduces barriers to entry, and this would result in differential effects across different market players. Or to put the last point differently, more easily grasped, is to say basically that barriers to entry or cost and uncertainty would affect different firms in the market in different ways. So for example, if there is a big firm, it would be less vulnerable to some costs and uncertainty as opposed to small firms in the market that may be subject to some harsher conditions as a result of the legal regulation. The second part, and one which I want to focus in the time which is left, how much am I left?
About 7 more minutes.
7 more minutes. That's a good watch you're having. The Private Security Litigation Reform Act. There was, just basically to summarize this slide, there are many public concerns about lawyer-driven entrepreneurial litigation in the context of securities class action and in other areas of class action litigation. And it basically summarizes, sums up to agency problem in class action litigation, which goes to the detriment of class members, of plaintiffs, and society more generally. This leads to social welfare calculus, which basically includes different components, and to highlight some of which, it is to say that some of those arguments aim at the socially excessive volume of suit, basically that there is overproduction, too much production of law enforcement. This would result in over-deterrence of defendants. They would have to take excessive precautions, and for some other chilling effects within the market. And also investors, the plaintiffs, are not protected either because of the agency problem and the different abuses within this context. To give you some numerical, some statistics, the volume of suit between 91 to 2000 was approximately around 200 lawsuits filed in each single year. And when I mean filed, those are the consolidated cases. So initially there were more than 200, but they ended up in 200 cases. And this chart does not mean in any way that this is...
We can't see the years there. The first one is what?
91.
91.
This chart does not mean in any way that this is excessive production of complaints or maybe too little. It just was, those numbers were just picked up by those people that basically argued there are those public concerns, there are those abuses, and this is something which should be taken care of. Some more statistics. What is the breaking the complaints in 99 only across different industrial sectors? What we see in the green area is that computer services, companies like Microsoft, Cisco, and other .com and not only .coms were subject to a large large numbers of lawsuits. And there are different reasons that would subject those companies, as opposed to others, say in the retail or insurance areas, to high levels of litigation. Some settlements figure, basically total settlements value from 95 until 2000 was about $6.6 billion, out of which the average settlement amount was about $14 million. It just gives you a general sense of how lucrative this entire business is for plaintiff law firms. The dominant law firm in this market is Milberg Weiss, which is a nationwide law firm. The average, they basically managed to secure about over $200 million in settlement value in every single year where they were in practice in the recent years. William Lerac, who is one of the partners, has about $7 million in annual income. This basically, once again, to show how this business is lucrative and what are the motivating forces underlying this litigation. This is a picture, by the way, of William Lerac. He was once was referred to as the most feared man in Silicon Valley. Just to mention that the computer sector of the industry is subject to high level of litigation. This person is not very much liked in boardrooms across the Silicon Valley. Later on, he said that I have the greatest practice of law in the world because I have no clients. And this, once again, just exemplifies the point that this is lawyer-driven litigation as opposed to client-driven. Those concerns basically led to pressure for legal reform, and the reform were to curb, the goals were to curb the lawyer-driven litigation and to shift the balance more towards client-driven litigation. The reform resulted in 2 acts and some judicial activism. And to some of the empirics, I'm just going to skip the hypothesis.
Wait a minute, you're not gonna tell us what you're testing?
I'm going to tell it in between.
Okay, because you're now out of time.
Basically, the hypothesis is that, as I said earlier, once we focus about the effects of legal regulation, the indirect effects of legal regulation on the market, I would expect that some legal regulation which was introduced by the Reform Act in '95 would increase the concentration in the market and reduce the competition. What we can see here in this pie chart is the market fragmentation in 1990. What we see is that there are many small firms with 1 or 2% of the market, while Milberg Weiss possesses 13% of the market. Its market share is 13%. In '92, we basically see something very similar, where Milberg has 15% and still the majority of the market is still highly fragmented. In '95, which is the year in which the act was enacted but still did not become effective, the picture of the market structure is basically the same. In '96, once the act becomes effective, Milberg increases its market share to 24%, and those other firms, we see less firms with 1%. The market is more concentrated, less market players and higher market shares. We can compare before '95 and after '96, after '95, before and after the act. If we take out those small firms with 1%, Milberg Weiss, the dominant market player, has 24% in '95 and gets up to 44% after the act becomes effective, which basically gives rise to my argument that the legal regulation introduced in '95 increased the market concentration and reduced competition.
The percentages in dollar amounts,
Those are percentages of the market.
but
No, in number of filings. Number of filings. Those are also other empirics about concentration values in the market, and I will have to skip that as well. Basically, I think I will.
No, you go back to the last, don't.
Nothing went wrong.
What went wrong? What went wrong with, and that's one of the questions about the legal reform in '95. The question is, why did the legal reform, which basically, as I said earlier, intended to reduce the power of lawyers, of plaintiff law firms, to curb lawyer-driven litigation and shift it toward client-driven litigation, why did we see the counter effects in the market? We basically saw that the act just increased the concentration and increased the market power of those plaintiff law firms, especially of Milberg and some others. And my argument is that a market model would enable us to evaluate the effects that the act had on the market. And I would say it differently. Had they had in Congress, when they crafted the Reform Act in 95, actually based on a Yale Law Journal article published in 93, had they had the market model, they may have been able to realize or to examine what would be the effects of a discrete regulation of some components of a class action litigation and evaluate or predict what would be the market effects. And as I argue, a market model is and ought to be the right framework to analyze those effects. That's something I can skip. It will take me, or maybe I should end here. I will let you decide. Okay,
What?
just to the conclusion.
Oh, okay, go ahead.
I will
We'll
skip
ask
the
you.
other charts.
Okay.
Just to summarize what I've presented up until now. First conclusion is that, which is a more methodological, analytical one, is that the production of law enforcement through class action litigation should be viewed and analyzed within a market model, which I lay down its components and features. The social objectives of law enforcement, once we have a market model, depend inter alia on the structure of the market for securities class action. So, in other words, competition, concentration, barriers to entry, and other features of market structure would affect the social objectives of law enforcement. Legal regime and discrete regulation of class action, and once again, those are not regulation of the market, but rather of the class action of the procedure, affect the market structure in different ways and confer more market power or reduce competition. It depends on the specific case. And having laid this model and those insights, it is possible to extend the use of this model to explore other areas of collectivized law enforcement and class action in areas beyond those of securities violation. For example, mass torts, consumer protection, and those of civil rights litigation. But in the present research, I'm focusing only on securities, mainly because there was intense legal regulation of securities, which makes it a good test case, and the relative availability of empirical data in the securities context as opposed to mass torts, human rights litigation, and other consumer protection cases.
Thank you.
Thank you very much.
Now I'm going to ask the first question, which will probably take you back to some of the charts, because the
Okay.
missing step,
Mm-hmm.
which I don't doubt might be missing because of speed, is what's the precise link between the provisions of the law and the resulting concentration of the market?
Okay.
You're telling us generally that one affects the other, but I don't understand
Absolutely.
what it was in that law that led to that concentration and why they didn't anticipate that.
Absolutely. I'm going to go into a chart which addresses this question.
And Guy, also, do you have data about other sectors of law firms? I don't know, corporate lawyers. Maybe in the same years there was also concentration in corporate lawyers segment.
Well, first I would start with Anne-Marie's question. How would, not only because I don't have the answer to yours, but at least in any case, I just put it on a. That necessitates to go back again. F5.
Yeah, you had the right chart, I think, the term.
Yeah, but I wanted to get directly into it instead of going. The connection between the way
There you go,
the legal
determinants of market structure.
right. Let's see if it's gonna work. No. Anyway, I'm gonna talk in the meantime, skip through the slides. The way that the legal regulation affects the market structure, and I take it that this is your question, is basically that some of the legal regulation that we observe, and actually one of my, that actually would give a good answer here. What we see, that's the schematic presentation of how a security class action look like, usually. That's before, under the legal regime before 1995, before the Reform Act was enacted. what we see once the Reform Act is enacted is different effects or different regulations introduced. The first thing is that stock price is now protected in the safe harbor provision introduced by the 95 Reform Act. And a safe harbor provision, just to elaborate in 2 words, basically means that some stock price drops would not be a cause of action for a security class action. So if you think just about the introduction of this new regulation, how would that affect different plaintiff law firms acting in the market? For some firms, those that are less well situated or less capable as far as financial ability is concerned, that would impose some additional cost, or that would increase the uncertainty over the prosecution of a case in which the application of a safe harbor provision is not that certain, not that clear. To take one more example, the soliciting of investor. The Act in 95 introduced a new regulation which basically prohibited what is referred to as professional plaintiffs. Let's think for a second about the legal regime before 95. A plaintiff law firm could solicit an investor, say you invested in a stock and the stock price dropped and I, as law firm, want to prosecute this case. So I would call you and ask you to become a plaintiff. And maybe I would offer you some side payment or not. But even if everything is done legally, you would come and the case would be filed on your behalf. After the 95 Act, professional plaintiffs, who are plaintiffs that serve as plaintiffs in class action litigation for 5 cases in a period of 3 years, are prohibited from serving as plaintiff anymore. So for some firms in the market, it would mean, or it would be translated into higher costs, because instead of contacting you once, time after many times to solicit you as a plaintiff, they would have to find new plaintiffs and solicit them. And I'm not going into many details, but this provision would basically be translated into additional costs. One more example is the heightened pleading standards, which were introduced by the 95 Act. And this, once again, there are different requirements that should be satisfied after 95, but were not required earlier. And this could be translated, once again, into higher costs of drafting those complaints and in satisfying and showing evidentially those requirements. And in addition, it also increases the level of uncertainty over the litigation, because it may be easier for a defendant to dismiss the case based on the heightened security pleading standards. All those, to summarize what I've just said, is that all those provisions, all those new regulations introduced by the 95 Act, and then there are later provisions that introduced by another Reform Act in 98, basically affect the cost component for those law firms or the uncertainty over the litigation. And when we think about those plaintiff law firms, in the end of the day, they are business entities. Although they are prosecuting cases which have conferred benefits on the public generally, and some attorneys I've spoken to refer to this litigation as public-minded litigation. It's not public interest, but it's public-minded litigation, and as a term of art. At the end of the day, they are business entities, and they take into account the cost and uncertainty components, and this would affect differentially different market players. Milberg Weiss, which is the dominant market player, would be affected in different ways, as opposed to, say, a law firm which is in practice only for 2 years and has less human resources and less capital, its own capital, to prosecute those cases.
Okay, one just follow-up question. Does the increased concentration in the market structure does it result in more or less cases?
Okay, that's actually a very good question, and that pertains
Because
more.
that's what the Act wants to achieve, right? They don't care who prosecutes them, they just want fewer ones.
I think they care about both. They care about achieving less cases, reducing the volume of suit, because they perceived, at least they argued, that some of the cases prior to 95 were frivolous, with no
Right,
merits,
right.
and ended up in blackmail settlements and the over-deterrence and the associated cost. But I think they also care about which firm or which company, which brand, to speak, to use it, would produce the litigation. Because Milberg, for example, may be a very good highly qualified and competent firm, as opposed to some new firms that maybe are less experienced. So I think that the Congress cared about both features of litigation, not only reducing the number or setting the volume of suit at the optimal level, but also setting the quality of the prosecution and the outcome of the prosecution at an optimal level. And as I said earlier, in a response to a clarifying question that was asked, I think by Shachar, or I don't remember, but defining the good, the commodity, is something which is contingent upon the volume of suit, the quality of prosecution, and the outcome of the case. So basically, I think that pertains to the,
measure quality.
how do you measure quality? Well, it is hard to
You're
measure.
next on the list, and then
But,
Yishai. So
okay.
yeah.
Okay. Is Shachar, who's the next?
Shachar,
Shachar.
he can piggyback that one and then answer the
Okay.
question.
So, I have some. You mentioned that there is a concentration in this sector, and I'm wondering whether you checked other sectors, corporate lawyers firms, to see whether the act indeed affects.
Well, I think it's a good question, but it's one which is hard to examine. And it's a good question because, for the following reasons, which I just think of hand. Comparing the market structure of the plaintiff law firms as a market segment or as a sector in the legal services industry to other sectors as, for example, corporate defense firms, and examining the effects of the act would perhaps give a test case or some experiment to examine or isolate the effects of the act on different sectors of the market, and perhaps see whether those effects that I'm arguing are really effects of the act and not effects which are due to any other factors in the market or in the economy more generally. However, I think it's quite problematic to examine those effects, first because the data is not readily accessible in all sectors of the legal industry, this market for legal services, although it may be possible to derive some empirical data. But moreover, I think it is hard to compare those two sectors because although they are broadly defined within the same market, the market for legal services, and then we can define the market to different segments, those firms operate on very different business models. Plaintiff law firms, just to mention one major difference, differ business-wise from corporate defense firms in their financing model. Corporate law firms are compensated for their legal services on an hourly rate. So they basically, for whichever hour is expended by a partner, by an attorney, or by a paralegal, they bill their clients. In the plaintiff segment of the market, the pricing mechanism or the compensation structure is very different. They basically are compensated on a contingency basis. And a contingency basis then has some derivatives of whether it's a percent of a recovery, say 25 or 30% of the recovery that they secure in a settlement or a judgment, or whether it is what is referred to lodestar mechanism. But in any case, working on contingency as opposed to working on billable hours basis, I think gives very different incentives and very different compensation structure, which is one reason I think it would be hard to isolate or examine those effects in a clear-cut fashion. And in addition to that, in the corporate segment of the market, the clients advance the costs of whatever legal services they are being provided. So they pay the law firm both the costs and the cost of conducting whatever task is at stake, but also the cost of legal services, the compensation for the lawyers. On the plaintiff side, they prosecute those cases based on their internal resources or based on debt that they acquire from banks or otherwise. So basically the financing model is also very different, which would make it very hard to compare.
Is that both questions or?
I think, hopefully.
I have a few questions.
Okay, all right. Yishai.
It was really, really interesting, and I want to hear what you have to say to what I have to offer you. So So as regards your narrative, so you start with a very elaborate structural analysis of what happened, and then I thought that the moment in which you showed the face of this lawyer was very telling, because that was the moment in which the structural analysis actually broke down and it became understanding what is it about as a matter of fact.
Okay.
And what I read you is actually as doing a classical CLS move.
I couldn't have expected otherwise.
You did or didn't?
I couldn't.
So I'll tell you why. Because what you're showing is actually, that there was these structural changes, there was this structure, and then it changed into another structure, and all these rules are pretty much neutral. I mean, if we just read them as they don't seem to be discriminating or favoring per se one person or the other, but they have an effect.
Right.
Their effect is of exacerbating, let's say, inequalities. They in a way, they disregard a baseline which has, as it states, that this firm, I forget now the name,
Milberg Weiss.
Milberg Weiss, has all the infrastructure and all the knowledge and the know-how and many, many things, and what the other ones don't have, that's what
Right.
we call baseline.
Right.
And then on this baseline, you have a structure of neutral legal rules, and they somehow exacerbate inequalities, differences, and they enlarge gaps rather than bridge them in a way. Now, the surprising element, and that's, I think, the subversive part of your dissertation or of the paper that you presented, is that we didn't think that that's where you were going, because what you talked about was about the volume and quality of the good, which is the law enforcement. But when Shachar asked you, so is it, are we reaching some optimal level, or do you even have the criteria to tell us, are we nearing or are we actually getting far from that? You weren't able or weren't willing to give the reply, and the only thing that actually you did tell us is that the structure created inequality, or it helped the stronger, it deprived the weaker, but you have no idea, is it good for the public? That is, maybe there are more claims, maybe there are more claims, maybe there are less, maybe the quality of the commodity is good, maybe it's not as good. You don't know, you're actually differential or ambivalent towards this question, but what you do know is that the face that you showed is probably much happier.
Well, I think I would.
That to see what you have to
My
respond
reaction
that.
to. Well, I think that your first part of your comment is a valid one, which obviously the act could be read neutrally, and I think that in Congress they did not think about, or the authors of the Yellow Journal in '93 did not think about any baseline or any achieving any equality as per law firms. But the acts could be read neutrally. However, once we introduce the indirect effects, then we get to what I presented here. To go to your second part of the comment, which I think is the more critical one, is whether I can point out or whether I can say anything concrete and explicit about the effects of the structural changes that I've showed on whether we are closer or getting further away from the optimal level of the public good that I'm trying to describe. And it is hard to say in any economic analysis of the effects of any legal rule, it is hard to say to measure those effects and to say, well, we are now that far, or we just passed it and we should just turn around. It is very hard to quantify those effects. However, what I can do, and I think which is readily available, is to point out the effects of the structural changes on the determinants of production of public good. Or let me phrase it differently. I can more readily say, well, a more competitive market structure as opposed to more concentrated, or maybe take into account barriers to entry and other features of market structure, be it market power, market shares, etc. I can pinpoint and say, well, a more competitive market would affect those features of litigation through class action in this direction. But those same market structure effects would affect other components of litigation in a different way. there is no uniformity in the effect that they carry on the litigation, which makes the objective of quantifying or fine-tuning the effects very difficult or very tricky one. So basically what I can come up with is saying, well, the law enforcement has some determinants, some components which are crucial, and those include the level of investment in litigation, and those include the level of agency problem and shirking on behalf of the counsel, of the principal, to the detriment of its clients, of the plaintiffs, and several other features and components of law enforcement. And then I can take each one of them, break them into specific features and say, well, the market structure would affect this component, this direction. Other component would maybe affect it, get different results. In the end of the day, what we have is a matter of trade-off. And some effects would offset the effects of others. And it's hard to pinpoint and say, well, we are here or there. But at least point out, highlighting those effects and the determinants of law enforcement correlated with market structures is something which I can do, and I think is basically the purpose of this project. Yeah.
You're next.
I have two comments or suggestions. First, I personally have a difficulty in understanding the framework of treating it as a market. So first, about the definition of a product. You said the product is somehow a consideration of the number, the quality, and the volume of, I don't know, the
Volume of suit.
volume. So I think if you're talking about law enforcement, so I think the product should be obedience or following the law. I mean, so you can have an extraordinary number of suits, well litigated, huge fees, but it means that everybody's cheating in the market and there's no law enforcement. So I just don't see the connection. So that's first. Now, second, I think when you talk in law and economics about enforcement and how you want to achieve it, so there's like a cost-effectiveness analysis, and there's private law enforcement, there's collective private law enforcement, there's public law enforcement,
Right,
there's
absolutely true.
regulation, you can make taxes, subsidies. I mean, society can have as many routes to achieve law enforcement. Now, in the securities context, I think, I mean, like you gave the number, and we talked about yesterday, the number of, like in last year there was a $6 billion volume of suits, and I said that in my perspective, it's not much, or if William LaRock does 7 million yearly, I think partners make much more money, so I don't think that there's such a big volume of suits, and I think the reason is that there's an excessive regulation in the securities context, like the laws of 33, 34, the SEC. I mean, you have excessive like revealing requirements of firms going public. So I don't understand like the relative importance of
Excessive means too much or just a lot?
the laws bind companies to release a lot of information to the market.
No, I'm just saying if you meant too much or just a lot.
By
When you say
excessive. Are you saying that it is socially undesirable?
No,
Or it's
I
you're just
think-
saying that-
I think you said there's excessive or lawyer-driven suits. I think that relatively doesn't seem like a big volume of suits. And I think the reason is that there's a very big body of regulations. Again, the Acts of 33 and 34 and the SEC that supervise what firms are doing. And if you want to justify like this class actions, why they're needed, so there should be like you justify private law enforcement by saying that the people who are bringing suit, they have some information that the authorities don't have. And your chart, you said these people see a drop in prices, they go and sue. I mean, that's something that a government agency can do. So why do we need that if that's their source of information?
So let me answer your comments and questions and break it into pieces. The first part of your comment about what are the outcomes of this and whether those are desirable effects or not, and you point out to obedience, law obedience, and You say, well, it could be that the level of enforcement is such and such, but still everyone cheats in the market, so maybe in the definition of my product, in the commodity, I should include legal law obedience. And my answer to that is very simple. If you just recall the black box I mentioned during my presentation, I said that this black box can contain different social objectives. And the social objective that I focus and that is the prime social objective of securities law enforcement is that of deterrence of cheating in the market, deterrence of corporations engaging in not disclosing information that they are supposed to disclose or misstating information in their financial documents. So basically the social objective is the one of deterrence. And if you translate deterrence, deterrence is readily translated into law obedience. So if we set deterrence at the optimal level, the socially optimal level of deterrence, then those companies would be effectively and optimally deterred from engaging in what qualifies later or what is later alleged as violation of securities law. So in that respect, I think the definition of a commodity is one which captures both social objective that you're mentioning, that is just a social objective that you take it one step further. I'm talking about deterrence, and deterrence is, as I say, readily translated into law obedience. And in this context, we're talking about obedience of publicly traded companies as far as securities regulation direct them to disclose or not to disclose information. As to the other parts of your comment about it could be that the numbers that I presented, $6.6 billion in total settlement value from 95 to 2000 does not occur to you as an excessive volume of suit. So first, just as a side note, I was not, my purpose in presenting those numbers was not to say that those numbers represent socially excessive volume of suit or socially excessive or over-deterrence in the context of securities. I was just presenting those numbers as numbers that were picked by people in Capitol Hill and by different scholars when they argued quite vehemently that there are public concerns and there are abuses in the context of securities litigation, and they point out and they say, for example, CEOs of publicly traded companies point out and say, look at those settlements. The average settlement amount is about $40 million. Then take a look at what are the attorney fees that, for example, Milberg Weiss or other firms generate from those recoveries, and they would generate, for example, something which ranges between quarter to 1/3, so that would sum up in a few good millions. We're talking about serious money. So those numbers are basically numbers that were kind of, I think, voice the concerns that different scholars and different lobbyists from both the consumer sector of the market and the publicly traded company sector of the market voiced when the Reform Act was crafted. But to go more substantively into the comment that you mentioned, I think that we should have a baseline to compare and say, well, 6.5 or 10 billions is a large or small number compared to the socially optimal level of enforcement in this context. And it's very hard to say what is, just as my reply to Ishai earlier, it is very hard to say what is the benchmark. It is very hard, as you know, because you subscribe as well to the economic analysis, it is hard to quantify as opposed to Ishai.
Why?
No, I'm kidding.
Full-heartedly.
Full-heartedly. It is very hard to quantify and pinpoint exactly what are empirically those effects. So along those lines, it is hard to set a baseline and say, well, compared to this baseline, those figures are excessive or are undesirable, or maybe we should curb it in this or other way. And finally, the final response to how I'm doing on the time.
There's just a bunch of people on the list, but go
Okay,
ahead.
I'm going to be brief. To your the final part of your comment about different forms of law enforcement. Indeed, there are different forms of law enforcement. Private law enforcement through individual suits or private law enforcement through class action, collectivized forms of litigation just show only one fraction of the entire enterprise of law enforcement. We have, both in the securities context and in other contexts of social life, we have different mechanisms and different institutional settings to enforce the law. And we have, for example, just to mention the securities, we have the Securities and Exchange Commission, which also has an enforcement division which conducts investigations and also pursues civil actions against publicly traded companies. It is, once again, those mechanisms may supplement each other or may also exacerbate some effects within each other. And it is, once again, very hard to come up or strike the fine balance between all those different organizations and those devices to bring about the optimal level of law enforcement. What I can do, I think, at best, is just focus on one mechanism and say, well, what happens under the province of this law enforcement device, and perhaps also delineate the fine lines which would say, well, in those cases, say, and you mentioned information, it would be more desirable that those private agents that do have information would bring those cases, as opposed to other cases where information is more readily available to the government. It would be better that the government would pursue the law enforcement.
It's related, but I can wait. I mean,
Really
it's
put you-
about the relationship between the different ways.
Well, I've got Gabby, Mikhail, Oren, Joel, and you.
Right.
Okay, and I'm gonna turn over the discussion to Ben, and I apologize for that. These are just not ordinary times.
Okay.
And I passed my turn.
Ah.
It makes any difference to you all.
I'll just sort of slide around here, and let me just say, I have to leave at 10 to 2. I've been summoned into the presence of the president of Germany, so don't take it as an insult. But
I'm also leaving soon.
I was gonna say, I just turn over the list to Guy,
No, I'm
but
kidding, I'm kidding.
I hate to cut the discussion short, but anyway. Okay.
So who's next?
Gabby is next.
Gabby, okay.
So I think you've answered part of my question already, but
That's a
I
good
will
start.
but I will probe a little further. So the question has two parts. The first one is more definitional and concerns deterrence. And I think you use deterrence both as a component of the commodity and as a criterion for its optimal measure.
Okay.
And so how do you settle both of these aspects? And then is it only deterrence of the companies who are potential defendants or also to those lawyers who might be engaged with, from the legal services side, to those lawyers who
Okay.
might engage in frivolous actions? And this brings me to the more substantive question, and that is, from what you say, it sounds like you think that lawyer-driven actions, that's not a good thing, that we need to change the balance so it's less lawyer-driven and more, so you don't have these professional people who go around and engage in frivolous actions.
Okay.
And one of the arguments is that they make way too much money. So I don't know, for instance, quiet divorce settlements make a lot of money. That doesn't mean that lawyers, encourage too many
Right.
people to get a divorce.
Right, absolutely.
So, and when I think about class actions, obviously I know very little about it, but it's mostly those cases in which you won't. True.
I was going
that
to say
you-
because you didn't come to my workshop, but okay.
Fair enough. But it's exactly those cases that a potential defendant or a sole defendant would not go to sue, right? That you need this mass.
Not necessarily. There are some
So not
refinements.
maybe in a plane crash, but if you think about
But
too
otherwise
much
you're right.
bank interest or
Right, you are absolutely
fraudulent
right.
cell phone payments,
You're
et
absolutely
cetera.
right.
And in that case, it seems to me that being lawyer-driven is almost the only way,
Absolutely.
to go about it. So what is inherently or germane difference that, between class actions and any other type of lawsuits that also may have, frivolous action?
Right. Okay. So I will go like part in part. I will break your Thanks for the question. The first question about the criteria and the definition of a commodity, because I'm using deterrence. And you're very true about it. I'm using deterrence both in the definition of a commodity, because the outcome of the law enforcement, we measure it by deterrence. And we would say, well, the deterrence effects of one action is such and such as opposed to other action. Still, deterrence is also the normative criteria I'm examining the effects against. But when I'm talking about the normative criteria, I'm not talking about deterrence generally, I'm talking about optimal deterrence to the extent that we can define or set optimal deterrence. And optimal deterrence, just to mention the economic theory of deterrence, optimal deterrence would be that would be the level of liability imposed on wrongdoers, generally in any context of civil liability, that would deter them from engaging in violations of the law, but the benefits of deterrence would not be lower than the cost of obtaining this deterrence. Very straightforwardly defined. So when I'm talking about the normative criteria, I'm trying to I am aspiring to the optimal level of deterrence in the securities context, and it would be translated into to what extent do we want publicly traded companies to be fully compliant with the regulations that are imposed on them, of disclosures and otherwise. And the commodity definition is one which includes the outcome in terms of deterrence, but whatever outcome is there. So there may be a gap in both directions, but I think it's not inconsistent to use deterrence in both parts of normative criteria and the definition.
So it's
To
not
go-
a definition of the commodity. That
Sure.
is, I mean, it's not a definition of what the
It's a
commodity
component.
is.
It's a component of the commodity, because when I'm talking about law enforcement produced in the market, I'm not only caring about the number of lawsuits produced, about the level of law enforcement, the volume of suit. I'm also concerned about the quality of prosecuting those cases. I care about that good lawyers would prosecute those cases instead of bad lawyers, because bad lawyers would not be able to impose the right level of liability on those defendants. So we care about the right number of suits, the right level of quality, and basically that would lead to the level of deterrence. And this should be examined against the normative criteria, which is the optimal deterrence. Now, to go to your other part, when I'm talking about the lucrative attorney fees, once again, as I said, I responded to Dotan, it is also a major argument which is used partisanly by different people when they make different arguments about lawyer-driven litigation. But you are absolutely right, because when we think about class action litigation, in most cases, not solely, not entirely, but in most cases, we're talking about securities cases where every individual investor suffers very nominal loss, or we're talking about consumer protection. Say Verizon overcharged you or rounded up the charges in few cents. You obviously won't have the incentive to bring litigation unless there are lawyers or any other agents that would be incentivized strongly to bring this litigation, and the incentive lies in the lucrative attorney fees. So there is nothing wrong about it. What is wrong about it is that in the context of class action litigation, as opposed to litigation, individual litigation, say you filed a lawsuit against the university or against any other defendant, the problem of class action litigation is that because each plaintiff has such a nominal stake in the litigation, and say you suffered, even if you suffered $200 loss because you invested in some stock that its price later dropped in the market, you would not have incentives to monitor the performance of your counsel, of your attorney, as opposed to a larger case, a larger complaint, when you would work, hand in hand with your attorney. What this gives rise not to a straightforward agency problem which exists in any institutional setup of litigation, but this exacerbates the extent of agency problem and basically leaves the attorney unmonitored entirely. And this is a problem. If you think about the lawyer-driven entrepreneurial litigation, there is a nominal plaintiff with no effective monitoring, no incentives to monitor, and the council's control over litigation and settlement is entire control, which basically, given together with the lucrative attorney fees, there is a strong motivating force to pursue those cases for the plaintiff attorneys, but they are not harnessed, are not disciplined in any significant way by the plaintiffs, which basically leads to some practices, abusive practices, that the Reform Act wanted to guard and avoid.
So it would then make sense to have a smaller market of specialized lawyers who have a reputation for.
Absolutely. So in that respect, a concentrated market may have desirable effects on some components of litigation. For example, the reputation. For example, the incentives to shirk or to exploit the case, to collude to the detriment of the plaintiffs. But on other components of litigation, the concentrated market may have undesirable effects. For example, if there is no enough competition, if you as a market player do not face enough or vivid competition from new entrants or from other law firms, maybe that would cut or downsize your incentives to perform well. So because you know that in any case you have a market power and there is no risk to losing the profits or otherwise suffering any loss.
Okay, Michael, please next.
Okay, let me say first that this is a great project. And
Thank you.
Since I had it yesterday, I already had some thoughts.
You're biased.
No, but I just had time to think, and my main comment is about the way you chose to present it.
Okay.
I think that what happened is, I mean, our goal and the optimality of deterrence and litigation are all connected to the question of what these rules want to achieve.
Right, the social objective.
And in this specific case, we are talking about optimal level of disclosure
Right.
and optimal level of fraud. We can pronounce it
Right.
or
No, absolutely.
Okay, and the question of is litigation is optimal, is there over litigation or too much litigation is connected. I mean, it's just the answer to it is do we get as a result of litigation an optimal level of disclosure or not?
Absolutely.
And I think maybe you should start from there and present it, and then your next step is that the literature that was concentrated on the optimal level of litigation in this context, or also I understand if you have broader applications, but I think what happens is that you start from the broad picture, and only then you focus on the practice of it, and
So you would
as a
suggest an
result, the
inductive approach rather than a
Exactly,
deductive one.
and as a result, I think that the broad picture is less understandable, and the value of what you say when you start to describe the market and having a broad view of the market, the value of the things is not, I mean, it's not as strong as if you just, just explain it at the end after you explain your analysis, and your analysis is very important because what you show, that like the literature that was trying to find the optimal structure of class actions in order to achieve optimal level of deterrence and as a result optimal level of disclosure and fraud, this literature concentrated just on part of the picture and did not include the effect of the rules on market concentration.
Right.
While market concentration on the supply side among the firms has in turn
Effects on the
exactly,
right,
effects
absolutely.
on the level of litigation and
Absolutely.
in turn
On the level of
effects on the level of
social
disclosure.
objectives, right.
Exactly. And so if you just write for yourself in 5 sentences all of your links, and you just go from the first link to the 5th one, and you describe all of them, and only afterwards you're saying my project shows that why the market approach is important, why it is important to include the effect on the concentration of the market, on the supply side, and the literature did not include, and probably also the regulator did not take it into account, and it is very, very important in it, then I think everything becomes much more clear, and,
Right.
and also the broader applications of the project
would be readily accessible.
Exactly, it's the value.
Actually, just a quick response to that. When I was thinking about how would I present the best optimally present my project. It was, the question arose whether I should start with the Reform Act and the problems of the securities, those slides exactly, like which are now in part 2, about the social welfare and the problems, cost of and inefficiencies in the securities context in particular, and only then broader the picture to say, well, that's the way it is, those are the goals of the act, and here I come and introduce a market model that would explain why the act had undesirable effects and how we should come about in thinking about it. But then I realized that the securities context, and in particular the 95 Reform Act, is just a test case to examine my broader project, which nevertheless, it could be right that it would have been better to
I agree, and also maybe to focus also on the differences
between.
between considering the supplies, how the effects on the supply side, and in turn this effect on the level of education, and between the results that you get when you don't consider it.
Mhm.
And then you exemplify your argument, I mean, very strongly. And then you can say that essentially there are broader applications to this view also in other fields.
Mhm.
And after you do this, it's very clear why there are. Because I agree with you that there are. I do think that also many of the questions we were raised because this is not the way it was.
Right.
Okay. Can I follow?
In the interest of optimal maximization of question time, I have Oren next on the list.
Owen is not
I'll
here.
give
Ah,
it up
Owen
now.
here.
Okay.
Very
Okay. Yoav?
Yeah. Great project.
Thanks.
I was wondering about the, expectantly maybe, I was wondering about the criminal side.
No, actually, I did not, but I'm very happy to hear about it.
Sorry?
I would like to hear about it.
Okay, so what I was wondering about is, I don't know a lot about the criminal side. I know that it exists with securities.
Right.
My interest is more with street crimes, but also with the opposition between street crimes and other
Commercial or
crimes.
white collar crimes.
Right. So how does it, when you speak about deterrence, how do you take, because if you're speaking about optimal level of deterrence, so the criminal side has an effect on the
Right.
optimal level, must have an effect, so maybe more criminal,
Right.
less civil, and so on. And do you have anything to say about the fact that we think about those issues in civil terms usually? We don't. I mean, your analysis is representative of the scholarship in this. I mean, we don't conceptualize these things, and we speak about deterrence. We don't speak about deterrence of street crimes in civil terms, right? We speak about it when we speak about deterrence of street crimes, we usually think about criminal law, and we think about the sanction that is prison.
Right.
And this opposition that has lots of explanations, but I wonder what is your relationship. For example, Posner would say, right, of course, we should apply the optimal sanction to the optimal defendant. So a street criminal should go to prison, whereas a member of the board of directors should pay money, and it's
Right.
optimal and it's fine. I
Well-
at least see some problems.
Well, I will try to respond and tell me if it is a response to your comments and questions. It is true that in the securities context there is also criminal law enforcement, and it is pursued solely by the Securities and Exchange Commission and the Attorney General rather than by private plaintiff attorneys. And this maybe would necessitate to introduce something that I did not introduce during my presentation. The social objective of the criminal law enforcement is indeed deterrence. And whether the sanction is imposed through imprisonment or through monetary sanctions, that's a different question. But and the economic analysis of deterrence would have something to say, indeed has something to say about the choice of sanctions, the optimal sanctions. But the social objective in the civil context of securities law enforcement includes not only deterrence, but also compensation for fraud, for the loss that investors suffered in the market. So it's not only deterring the companies for engaging in violations of the securities laws, but also compensating for the loss. So in that respect, the deterrence is only one part of the social objective of securities law enforcement. But when you, if I can,
Just to interject, this is part of how we conceptualize white-collar crime, but why not thinking about, for example, incapacitation? These people are dangerous people out there, sitting in those boards of
right.
directors. We don't think about it maybe as stealing, but they are getting richer. You know, if you think about this, it's a matter of, or for example, retribution. Aren't
Well,
they doing terrible things? I mean, not that I'm in favor of all these. I have my own reservation about all this justification of punishment and punishment in general, but I'm doubting the difference in conceptualizing white-collar crime.
as opposed to street crimes or other types of criminal behavior. Well, I think that if you subscribe to the economic theory of deterrence, civil liability and deterrence, and criminal liability, criminal law enforcement, then issues such as the relative efficacy or the relative effectiveness of the choice of sanction is one which would come into question. And the effectiveness of choice of sanction is not only a matter of retribution and those type of considerations, but also what is the cost of imposing or carrying out this type of sanction. For the state and for society more generally, it would be much more costly to impose imprisonment as opposed to monetary sanction, which is much cheaper, unless there are some other problems that the monetary sanction is not collectible, and there is a problem of what is referred to judgment proof. But unless those considerations are non-existent, then a monetary sanction would be more desirable because it would save some costs and would be cheaper for the state to impose. As for the different conceptualization of criminal laws, of different criminal behaviors and the security in the securities context as opposed to what you're dealing with, the economic theory, I think, would not come with any specific or any principled distinction, a conceptual distinction. It all comes down to the choice of sanction depending on the circumstances and the different variables that play different roles. But there is no per se definitive approach which would say, well, those type of criminals should be presumptively subject to different type of
But now you're
sanctions.
stating the dogma, which is sounds neutral, but it isn't. That's yeah. I'm asking more about.
I'm coming from the approach of analyzing and viewing those issues from the economic theory of deterrence and criminal law enforcement, and not from the whichever it's critical legal studies or other approaches that may be ascribed to those type of issues. So maybe that's something which lies in between. But I would take one more minute just to generalize about your question, about your comment, about the distinction between criminal law enforcement and civil law enforcement. What we would see, we could also think about criminal law enforcement in the terms of my market model. And what we would see in the terms of a market model, we would see that the supply side of law enforcement in the criminal part of law enforcement is fully concentrated, is monopolized, and it is monopolized by the state. There is no competition over there, there are no market players, and the state is the one that determines what would be the level of supply. And in a sense, you could view criminals as those that place the demand. But the state monopolizes this part of a market and determines the market structure, unless in other areas there is some privatizations of criminal law enforcement. And as I know, there are some areas where this is applicable. But there are also benefits to concentrating control within the monopoly of the state. And there are different benefits. I'm not going to go into it, but I think that we can extend the model to also analyze criminal law enforcement and other types of law enforcement.
Shaka, do you want to come back in?
I just want to mention that the level of suits during the last decade was quite constant.
Relatively speaking.
So you still have to explain why there was a concentration in the market, but still
The outcome of the market was relatively fixed.
Yeah.
What I can say in response, just a brief one, is that although the level of volume of suit was relatively fixed, and it was not necessarily so if you go back the level of volume of suit, we see that in 95 basically it reached the almost the lowest peak, but later on there is some increase. But if we examine this chart more incrementally, we would be able to pinpoint maybe perhaps the effects, not on the volume of suit generally across the decade, but more specifically, say what happened in 95 and 96, and what happened between 98 and 99 when another Reform Act became effective. So, but you're indeed right that that's something that requires explanation. One way to explain it is that although there was exit of firms from the market concentrated, and there was increased market power of some firms, which, although they had increased market power, they had to adjust and invest in accommodating the new regulations, and also Milberg Weiss had to do that to the extent that, as you said earlier yesterday, he did not do that earlier before 95, which I cannot tell, but there was exit of firms from the market, which basically allowed the big dominant law firms to attract the whatever share of the market that those exiting law firms left, and increase their market power. So just we have a different allocation of basically the same size of the market.
I have to hit the road, folks, but please don't stop on my account. Thank you.
חצי תשובה. אני יודע, אני תמיד עושה את זה. הייתה בסדר איתי. אז דילגת על כל מיני דברים, אבל... No, just specific.
I was just wondering, did you say that there's no economically neutral way to determine the baseline or to determine what the optimum
There is, I mean, you cannot come, it's hard to come with, I mean, you can determine that, but only verbally. You can say, I mean, in the sense that you can say, well, the optimal level is one in which there is a minimum, you minimize the cost of violations of the law, the social cost, and say for every misstatement, any indisclosure, there is some social cost suffered by the plaintiffs. So you minimize this cost, but in order to minimize this cost, you don't want to incur higher cost of law enforcement. So you want to strike